Jade. So today I'm going to talk about what is probate. This is a question I think a lot of people hear the word, but don't completely understand it. So probate is a legal process for receiving assets of a deceased person and determining who has the right to receive those. So probate proceedings typically focus on the existence and authenticity and validity of a will, if there is one. Probate can be initiated without a will, and even if you have a valid will, your estate will be in place, such as a trust. So you can avoid probate costs and the complexities and the time, as long as you have a proper estate plan with a trust, or using other investment vehicles that do not require probate. So probate without a will. So the probate process is a court-supervised proceeding where the authenticity of the will is proven to be valid and accepted by the court. So then the court will officially appoint an executor or administrator. If you have a will, it'll be the person that's named in the will. And it gives them the power to then act on behalf of the deceased at that point. But you have to get that from the court first, that approval. The executor, so a will typically designates a legal representative, who is known as an executor, and they're to be approved by the court. They will be responsible for locating, overseeing, accounting for, disbursing assets, paying debts if there are any. They'll be required to pay any taxes if taxes are due. They will be required to pay creditors. Creditors have, when it's probate, it's public. So creditors will, find out about this. They have a limited amount of time, usually 1 year, where they, from the date of death, to file a claim against the estate for money that might be owed to them. And then the executor will also be responsible for filing any income tax return on behalf of the deceased. And most assets are subject to probate under supervision of the probate court, in the place where the decedent lived when they passed. Now, the exception to this can be real estate. Probate for real estate will, if there's real estate in other states and this hasn't been provided for otherwise, it will go to the county where that real estate is located. Now, if you were to pass and you do not have a will or any type of documentation, you have not named anyone, you will be said to died intestate. That's the legal term for it. And the probate process for intestate includes distributing assets according to state laws. And the state law, which is an intestate statute, determines your heirs. And the court will appoint and approve an administrator to oversee. So someone, maybe a family member, usually will step up and volunteer to be the administrator, and the court will then need to approve that, and the administrator functions just like the executor that we already discussed. Now, avoid this, avoid probate, avoid courts at all, avoid public knowledge of your passing and creditors filing against your estate. Create and fund a revocable trust. Sometimes it's irrevocable, that's usually special circumstances, we could talk about that. But if you have real estate, if you have accounts, policies, other assets, especially if you have minor children, or just, even if they're getting a little bit older, there can be other circumstances. You probably want a revocable trust. You can also name beneficiaries, or also known as transfer on death or payable on death, on all of your accounts and policies, especially if that beneficiary is an adult and competent. If not, we probably are going to do a trust. This can avoid significant legal costs. If it can save your family, your beneficiaries, a lot of time, it can keep the estate private, it can avoid tax. Your best bet is to consult an attorney such as myself and get something in place to avoid all of that. So as always, feel free to reach out to myself, Jade Carpenter at Zeidman&Carpenter, and I'd be happy to help. See you next time.